I'm speaking with Lance Avera of the law firm of Avera and Smith, and we're going to talk about workers' compensation. I think probably all most people think about is the big poster that's on the board, probably in the break room, that has the broken arm, and you don't really read it, but you see the poster and you walk by, and we know that the employer has to post it. But there are a lot of things that people should know probably before they have an accident on the job, and that's what I would like for you to tell us about.
The most important thing is when an accident happens, however minor, is for the employee to notify their employer. Sometimes the problems with an injury might not develop for a day or two or 3 days after an accident, and it's just the best policy, no matter how minor the accident is to report it to their employer so there's no question about what caused it if it develops 2 or 3 days after the accident. So that's one of the most important things to do primarily, first off.
So employers should be encouraging their employees to just make this a habit. If you have any sort of a little accident, a slip and fall, or anything happens, just get it recorded and get it documented.
Sure.
Because is there a time limit on that?
There is a time limit. The employee's obligation pursuant to the statute is they have to notify their employer within 30 days of an accident. But my advice is if you have an accident, notify them on the first day. There's a reporting form called a notice of injury that has to be prepared by the employer. It's probably a good policy for the employee to get a copy of that or request that. If the employer does not provide that, then just notate the date and time in person that they requested that from so that they can document their files.
Or if maybe there's other witnesses around that watched it happen or knew why it occurred.
Get names of people that witnessed the accident, yes.
Okay, and then, 9 times out of 10 it probably doesn't turn into anything. But when it does, what is the next step if you have to seek medical help, for example, for your twisted ankle, broken leg?
If they go to a doctor for an injury, I can't emphasize how important it is for the employee to fill out the information sheet. Everybody, when you go to a new doctor, they fill out an information sheet to describe their health condition, past medical care, and it's so very important, no matter how minor the past condition is, to put it on that form. I've seen cases where someone had a back injury and had a chiropractic treatment 2 years before that accident. They didn't put it down, and there was an allegation that the employee was trying to hide that prior back condition from the doctor, trying to hide that condition from the insurance company. So it's very important for that employee to put all of his prior medical conditions on that patient information sheet that he fills out with the medical provider.
And I understand, I know I've been in a doctor's office and you just check this, check, and you get it and you go back in because you're late for your appointment and you want to get it over with. But what you're saying is really think about it, because you could honestly have forgotten about that chiropractic appointment and the end result is the same.
Yeah, an inadvertent omission in a prior condition could create a major problem with a workers' compensation case, especially if it gives the appearance that you're trying to hide a condition from the medical doctor and hide the condition from an insurance company. So the honesty is the best policy, of course, in every instance in life, but it's so very important in a workers' compensation case is to notify the doctor of all prior conditions, whether it's related or not to the condition that he's treating you for.
And just to be honest and upfront about everything that you can remember.
Absolutely.
Now,
Absolutely.
I know that you're board certified in workers' compensation law. And what is the difference between an attorney who has board certification in this particular area and one who does not?
Just as in every other area of law in Florida that offers a board certification, the lawyer has to demonstrate a higher level of competence in the area of law. It typically requires a great number of trials or hearings that they have attended in that area, and they have to undergo a very stringent or tough test and pass that test and be accepted by your peers in that area in order to qualify for board certification in the state of Florida. It is not an easy thing to obtain in the state of Florida under any of the areas of law that is where they offer that board certification.
And because it's so difficult, that is a justification for someone to look for an attorney who's board certified in the area where they're having their particular legal issue.
Board certification is definitely an advantage with a lawyer that has that certification, because he has demonstrated the competence level in that area. So you are getting a lawyer that has a higher level of competency in that area of law, and has proven himself with past cases and proven himself on a test in that area of law, that he is very familiar with it and understands it, and is going to be very knowledgeable and pass that knowledge on to the prospective client in that area of law.
And continues to do that on a regular basis too, to keep up with the current changes in the laws and things that they need to be aware of, or someone would need to be aware of if this was their legal issue.
You have to maintain casework and trial work in workers' compensation in order to be recertified by the Florida Bar, and I've done that and will continue to do that through my practice.
Good, thank you. Good information.